The Market Revolution, the Supreme Court, and Andrew Jackson. Historians for probably the last 25 years have begun to refer to the period of dramatic economic expansion that occurred after the War of 1812 as a market revolution. And I think probably the simplest definition of market revolution is this. The market revolution organized production on a larger scale for a wider market than home use. Before, most production was for immediate home use and local exchange and barter. With the market revolution, more and more production was for sale and profit. The market revolution changed in fairly significant ways how Americans lived, how they worked, how they made a living, how they thought about liberty and property. And I want to present at least three major ways in which the market revolution did this. First of all, the market revolution sparked a transition from subsistence agriculture to commercial agriculture. Subsistence agriculture, of course, means that the resources of the family farm and the land were used primarily to get the family to meet its food, clothing, and housing needs over the coming year. Commercial agriculture, of course, has to do with growing surplus crops, again, for sale and profit. The shift from subsistence to commercial agriculture was quite significant. It undercut the notion of safety-first agriculture, and I more or less just explained what that means. Safety first, that the farm was there to take care of the family. The farm and its land needed to be kept intact so that it could eventually be transmitted to the next generation. This shift to more commercial agriculture ended the important economic function which the family farm had played. In early American history, it is the primary unit of production. The shift to commercial agriculture is also going to erode the idea of patriarchy, that these family farms were owned and managed and supervised by the oldest male member of the household. The shift to commercial agriculture also affected women. Women had played an absolutely critical role in the family farm. They were absolutely indispensable in the rural household achieving independence. Women are going to lose that function. And finally, as a consequence of this continuing shift to democratic rural landscape also began to disappear. What do I mean by an early American democratic rural landscape? Well, in early America, the landscape featured mainly woodlands and pastures which were unfenced, interspersed with small amounts of cultivated land, cropland, enclosed by lawful fences. This democratic landscape kept any unenclosed land, any unfenced land, even if it was privately owned, could be used by anyone for hunting, fishing, gathering a subsistence, raising livestock in the open range system, With commercial agriculture, there are going to be more commercial crops, there's going to be more fenced lands, more enclosed lands, and poor people without land did not have the same access to common lands as before the market revolution began to change things. The second major change brought about to how Americans lived and worked, a shift or transition from self-employment to wage labor. The American dream, beginning even before 1776, was again to own a farm, to own land, perhaps to own and manage a small-scale manufacturing operation. Self-employment was synonymous with Republican ideas about personal liberty. A man, and this is a male-dominated culture and society, a man aspired to be the boss of his own affairs, to be able to live and work without the leave or permission of another. The push, as more and more Americans are going to have fewer opportunities for self-employment, as they are going to end up working for wages. This was a difficult transition. It was a slide into what early Americans called social dependency. And the first generation of Americans to experience this transition from self-employment to wage labor experienced it as a form of slavery. The phrase that was often used was the slavery of wages. The third major change which the market revolution brought about in regard to how Americans lived, worked, and made a living, a shift from small-scale artisan manufacturing to factory production, to larger-scale factory production. The artisan system was based on producing things in small shops that were run by masters and journeymen and apprentices. It was a way of making things that preserved and enhanced the dignity of labor. The objective was to take young apprentices, and by the time they had graduated to become masters, they would know everything there was to know about making a wagon or making shoes. So the shift to larger scale factory production is really based on making things using labor that is not terribly skilled. Factory workers trained, they are cogs in a machine, if you will. They are trained to perform just one small task in a larger production process. So this shift from artisan production to factory production, again, is going to challenge and discredit traditional Republican ideas about the labor theory of value and personal independence. The market revolution not only brought changes in how Americans lived and worked, but the market revolution forced changes in the law. The law had to change, it had to be modified to make it more suited to support this new economic order, this new capitalist economic order. And a major change in the law that is going to take place, the old common law of property is going to have to be set aside. The common law of property made a distinction between real property and what was referred to as merely personal property. Real property was land. And the law gave the greatest protection to real property, to land. Now, what was merely personal property? Well, it could take the form of goods, money, ships, bonds, personal notes, bank accounts. And while personal property received some protection from the law, that protection was not as full, was not as absolute as what was given to real property. Perhaps the best way to illustrate this is through an example. Imagine we have a merchant named Smith, and the merchant Smith sells a local farmer named Brown $100 of merchandise. And the farmer Brown pays for the merchandise by giving the merchant his personal note, which is a sort of IOU, a promise to pay what is owed within a specified period of time, perhaps 6 months. Now, the farmer's obligation to pay would be upheld by the law. But if the farmer later complained that the goods that he had bought were defective, that the quality was not what he expected, that the price he had paid was too much, a jury might cancel that obligation. And if the merchant ended up selling Brown's personal note, because that represented property, if he sold Brown's personal note to a third party, a court may or may not uphold the obligation. So personal property did not have the same status as real property. That would have to change. Personal property becomes increasingly important in this new market revolution. There was a second way in which the old common law of property also turned out to be somewhat anti-developmental. The common law of property had decided that the first use of land, which was often agriculture, that the first use of land, agricultural use of land, again got the strongest protection from the law. And the idea of using land as a productive asset, that was secondary. The premise here of the law seemed to be that the reason people hold property is more for enjoyment than to use that property as a productive asset. A quick example to show how the common law of property did give a strongest protection to first use of land. The old common law idea of what was called riparian rights. This had to do with if you owned a piece of land, you were a farmer, and you had a river or creek that flowed through it. This law of riparian rights allowed you to use the water that flowed through your land, but you could not impede the flow of water. For instance, you could not erect a dam and build a mill, because in doing so, you would limit and restrict the ability of owners downstream to enjoy the water and to use the water as the owner upstream could. So this law of riparian rights is going to have to change. With state legislatures and state courts doing most of the heavy lifting, the law of property is going to be transformed. There's going to be a greater and greater emphasis on property as a productive asset. Again, the state legislatures and state courts are going to do most of the heavy lifting with respect to changing and modifying the law so that the law could increasingly be viewed as an instrument, as an agent of economic growth and the market revolution. The Supreme Court did its part as well. I'm talking about the Supreme Court under John Marshall. John Marshall was Chief Justice. I believe he was the 4th Chief Justice of the Supreme Court. He had a very long tenure from 1801 to 1835. Marshall influenced the court and got it off to a good, energetic beginning as much as any subsequent Chief Justice. Marshall and Marshall's court are going to play a particularly important role in defending and protecting corporate rights. Corporations had an important role to play in early England. A corporate charter was essentially a grant of special privilege and power to a group of individuals, and corporations in Old England were used mainly to promote charitable and educational projects. Well, in America, after the American Revolution, corporations and corporate charters that are granted by government, charters increasingly are being used to promote economic development. And it is here that the Supreme Court is, under John Marshall, is going to make its principal contribution to the market revolution. Again, by definition, a charter is going to be granted by a legislature. It could be a state legislature, could be the Congress of the United States. And these charters gave special privileges and special powers. Marshall is going to feel very strongly about defending corporate charters. He believed that corporations were what he called artificial beings with individuality, and that the defense of these corporate charters was essentially a defense of property rights, a defense of vested interests, which were essential to the building of this new economic order, again, what historians refer to as the market revolution. The most important corporation that the Marshall Court is going to defend was the Second Bank of the United States. It was chartered in 1816 as part of the so-called American System, a national plan for economic development. And by the terms of the charter, the Second Bank of the United States was what was referred to as a mixed corporation. It was 80% private and 20% public. It was primarily a capitalist for-profit institution, which is given by Congress enormous public power, the authority to control the money supply in America. This charter is going to make the bank's proprietors and chief stockholders very, very wealthy. The bank is also going to become very controversial in 1819 when it seems to play a very direct role in the first major economic crisis of early American history, the so-called Panic of 1819, also known as the Crisis of 1819. In 1819, the constitutionality of the bank was challenged in a major case, McCulloch versus Maryland. And John Marshall and his court took the opportunity to vigorously defend corporations, to defend this particular corporation, the Second Bank of the United States. Marshall ruled that the bank was constitutional, that Congress had a wide discretionary authority to create a corporation like the Second Bank of the United States. And Marshall's ruling was very nationalistic. He said that the national government was supreme over the states in almost every instance. And he said that the Supreme Court was the decider of constitutional issues. The decision would later be challenged by Andrew Jackson. Jackson becomes president in 1829. At the end of his first term, Congress had passed legislation to extend the life of the bank. Initially, it had a charter for 20 years. And this legislation was going to renew the life of the bank and renew the term of the charter. Jackson feels strongly that the bank was an institution of elitist rule, that it violated the great constitutional principle that a government should not give special privileges and advantages to individuals and select groups, that government could not make the wealthy and powerful more rich and more powerful. That was the very antithesis of popular self-government. Jackson is going to veto this legislation. And his veto message put him in direct conflict with the Supreme Court. The court had said the bank was constitutional. Jackson says the bank is not constitutional. Jackson follows an idea known as departmental theory, which held that both the president and the Congress had the same authority and responsibility as the Supreme Court to decide on matters of constitutionality that came before them. Jackson had a different view of the so-called necessary and proper clause under which Marshall had found the bank to be constitutional. And Jackson also would invoke what some historians have called popular constitutionalism. Again, Jackson believed, unlike Marshall, Marshall said the court was the decider. Jackson believed that the people were supreme, that the people, only the people, had final authority to decide on constitutional issues. And since the bank was an institution of elitist rule that again violated the great principle that prohibited government from giving favored treatment to some that was denied to others, Jackson was quite comfortable in vetoing the bank on constitutional grounds. What was really going on here, I think, in this conflict between the Supreme Court and Andrew Jackson was a sort of conflict between capitalism in its early oppressive form and democracy, Republican self-government. And the conflict pitted two different views and understandings of the Constitution. Marshall's view was a nationalist view. Jackson's view was drawn largely from James Madison and his notion of a compound republic and divided sovereignty. This latter view held that the two governments, the national government and the state governments, were essentially equal. They had sovereign authority over different matters, but both governments were ultimately answerable and accountable to the people. The point of having two governments was the two governments would check one another. The revolutionary generation had a great fear of political power, had a great fear of too much government. And Madison's answer had been, let's take political power and let's divide it and divide it and divided. So Madison argued that political power was divided first between two governments and then was divided again. Both the national government and the state governments would have executive, legislative, and judicial functions. Madison called this a double division of power, which offered a double security for the rights of the people and for their self-government. What was perhaps the starkest difference between the two views, Marshall's view and Jackson's view, which was largely taken from James Madison, the most serious difference had to do with who decided constitutional questions. For Marshall's view, it was the Supreme Court. For Jackson, it was the people. The people were sovereign. The people should operate as an active sovereign. The people should essentially interpret and enforce their constitution. I think the disagreement and the controversy about the role of the Supreme Court at this time has something to tell us today. In the aftermath of the Dobbs decision this past summer, where the Supreme Court reversed the Roe v. Wade decision, this has invited a lot of criticism of the Supreme Court. There have been questions raised about whether a small majority of 6 justices should have this much power. Questions have even arisen about whether the Supreme Court is the proper forum for deciding constitutional questions, and I think it has always been the case, and early Americans recognize this. I think that's in part why Jackson was opposed to the Supreme Court, arguing that it was the final say. The Supreme Court is the least democratic branch of the United States government. It consists of appointed, unelected judges who serve for life. This seems to be in conflict with the foundational idea of popular sovereignty. And in part, America had fought a revolution because it disagreed with Parliament's assertion that Parliament was the English Constitution, that there was no practical distinction to be made between Parliament's authority and that of the English Constitution. Parliament said the English Constitution was whatever Parliament said it was. With the Supreme Court during the last 70 years, assuming the awesome power to decide what is constitutional and what is not, we have sort of come full turn in a historical sense, because to many, particularly in the aftermath of the Dobbs decision, it seems that the Supreme Court is in a position to say that the U.S. Constitution is whatever we say it is. And there are no other voices or opinions or sentiments that should be considered. Perhaps it's time for Americans to rediscover their past, to understand that the authority of the Supreme Court in the past was a lot more restricted, was a lot more limited, and maybe it's time to revisit the idea of who should decide what the Constitution means in a system of popular self-government. Thank you.